When does a race-neutral admission policy violate the Equal Protection Clause? Can schools continue to pursue diversity as a valid goal without running afoul of the law? How many times can we say disparate impact and invidious in the same episode?
I'm going to go with 37. What do you think?
All right.
That's the over-under?
We'll leave it to the audience to count.
What does invidious mean?
Is invidious not a word?
I don't know. I figured that was some law term that I'm not familiar with.
Yeah, it's a law term. Now you got me second guessing myself. An invidious distinction is one made on an illegitimate or offensive basis.
Okay. Now we know. And now you know.
Now we know.
Today we're going to talk about the Coalition for TJ versus Fairfax County School Board. It's a recent case revolving around the changes made to a magnet high school admissions process and whether those changes violated the 14th Amendment's Equal Protection Clause by discriminating against Asian American applicants.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Jamie, got a bell ringer for us today?
Yeah, I've got a bell ringer. It's kind of one topic, more or less, from two articles from two different states. One article is about South Carolina. The other article is about something that happened in Florida. So the article from Florida.
I hate that our states are always in the news.
I'm North Carolina.
Oh, yeah. Oh, you're the other Carolina.
I'm the other Carolina. But you're still right. Our states are always in the news. And, we're recording this episode right after Super Tuesday. So we had a lot of fun in North Carolina.
Oh, I bet.
So we'll probably end up talking about some of that stuff.
Mm-hmm.
So, yeah, we've talked a lot on this show about how laws are often very ambiguous, right? And so I came across a couple of articles that reminded me that not only are the laws ambiguous, but they're so ambiguous in some cases that this is all just getting ridiculous. So let me tell you what I mean by that. So let's start with the Florida article. So this article was in the Tampa Bay Times by Jeffrey S. Solochek. And this article was talking about how the State Department of Education in Florida is considering a new rule that would penalize principals for, quote, illegally preventing students from looking at library books.
Huh.
Now, you might be asking yourself, isn't Florida one of the states that said you need to prevent students from looking at library books?
Right.
And if that's what you're asking yourself, then you would be correct.
Yeah.
Because Florida is one of those states that said you probably should not have certain library books in your library.
Right. Florida kind of led the charge on that.
They sure did, at least according to that Pen America report that we talked about in an episode from the end of 2023. So all of this was sort of following Governor DeSantis's recent walkbacks of the law that he signed, which made the process of challenging books much easier.
Right.
And according to DeSantis, what happened was a lot of people started challenging books.
Well, that's fascinating.
It's amazing how that works, right?
Uh-huh.
And then he said, well, apparently there were a lot of, quote, bad actors who were abusing that process.
It's funny when It's almost like they politicized a political process.
Really?
For challenging books.
Yeah. So, so basically the State Department of Education was basically telling principals, better be careful. Don't remove too many books.
Right. Even though the thrust of the law up until this point, recent legal developments have been, hey, be really careful about what books you expose students to.
Exactly.
And so, yeah, like now we've got this, you're fighting ambiguity with ambiguity.
Yes. So this is similar to an article that I read from CBS News that was talking about something that happened in South Carolina along the same lines, preventing books from being housed in school libraries. So this was a story out of the county of Beaufort, South Carolina. And what happened here was a couple of people demanded that 97 books that essentially featured minority or LGBTQ characters, and some of those books that depicted elements of sex or violence, almost all of which were solely in high school media centers. There were a few that were sort of part of classroom curriculum, but the vast majority were just in the media centers in high schools. So a couple of parents demanded that 97 books be removed. Now, in the county of Beaufort, parents have the right to tell schools that their kids can't check out certain books.
Huh.
Okay. So they basically have this sort of opt-out policy, which we've kind of talked about these things before, right? And interesting in this article, the interviewer asked the school official if that had ever happened before, and the school official said no.
Sure.
No one has ever exercised that right.
Mm-hmm. Well, it's one of those things where like you've got these policies written down somewhere, and whether or not anyone knows the policy exists or ever takes advantage of the policy, like they're still written down somewhere. Somewhere.
Yeah, exactly. The other thing that connected these two articles for me was the fact that in Beaufort, a parent showed up to a school and said that school was violating the law by having all these books because it was pornography to minors and all that stuff. And so the superintendent feared violence and thought that the ramifications of having those books in the library would be significant. So the superintendent pulled all those books.
Okay. So went along with the demand.
Went along with that demand from apparently one parent or a couple of parents. But the interesting thing about this article to me was what that town did as a result. The town asked volunteers to actually read the books.
Hey.
Because it seemed as though so many of those books were being challenged by people who hadn't even read them. That's interesting, right?
Well, that's something that kind of happens a lot.
Yeah.
There'll be lists of books that just kind of get circulated, and people will take that list, cross-reference it with what's in the school library, and will challenge everything that appears on the list. Like that's been going on.
And they won't know anything about those books.
Right. Yeah. And that's been going on for decades.
Yeah, exactly.
Like that was actually what happened in
the Pico case.
The Pico case. Yeah. These parents went to a conference, got a list of books, went to their school library, found if the school library had those books, and challenged them.
And I think the same thing also, I think it was Counts versus Cedarville. I think that was the challenge to the Harry Potter.
Oh, having the Harry Potter series?
Yeah.
I think you're right. Yeah.
It promoted witchcraft and whatever. And I don't think those folks had ever read the books. But
I mean, I wanted to be a wizard after Harry Potter. So like it definitely promoted it for me.
Did you get a hat with the stars on?
I never had the hat, but I did have a wand.
Okay. All right. So the interesting thing here about this particular case was what the town did, and they asked volunteers to read the books. And what happened was over the course of the year, there were a bunch of discussions and deliberations, and essentially what was sort of described in this article as, akin to book clubs, right? Where people read these books and they talked about them. And there were about 146 community volunteers, in addition to the teachers and the librarians and other, school officials who were asked to review these books. And the result was almost every single book was deemed to be perfectly appropriate.
Okay.
There were a few that the group said might have been too graphic in sex or violence, but the rest, 92 out of 97 books, were deemed perfectly fine.
Oh, nice.
So these articles just kind of reminded me as ambiguous and often problematic as some of our laws and regulations might be. Let's exercise some common sense.
Yeah. Well, and it just kind of shows that, like, you know, these ambiguous laws, there's lots of play in the joints, and we can do these kind of knee-jerk reactions, or we can kind of be deliberate about it,
right?
Put these processes in place to, like, really analyze to make sure that, like, we're not just doing this out of a sense of fear or a desire to avoid kind of potentially challenging outcomes.
You know, those are two articles that are following this sort of theme that we've been threading through this podcast about these educational gag orders. And, you know, we're talking about this stuff a lot because A, it's important and it's current and it's relevant. And B, it's constantly evolving.
Right.
So there's lots to talk about.
And quickly too.
Yeah,
right.
Exactly. Exactly. All right. Well, you ready? Let's dive into TJ.
Yeah. Speaking of something that is relevant, current and quickly evolving.
Exactly. Yeah. So this case we're going to talk about today was recently denied cert.
You're not going to try to say certiorari?
It was denied certiorari. No, I'm not. See? Words. So this case was recently denied cert by the Supreme Court, which basically upheld the lower court's ruling. And we're going to talk about all that stuff, but this was really recent. So they denied cert. When did they deny cert, Chris?
February 20th.
Oh.
Also, a note, denying cert means that the lower decision stands. It is not any indication of the Supreme Court's opinion about the lower decision.
Right. So they're basically saying, we're just not going to take this up, right?
Yeah.
And we're talking about this case. Now, we mentioned this case in the last episode, Bell Ringer, okay?
Yeah.
Because that was right when the Supreme Court denied cert, so we wanted to basically acknowledge. And then after that episode, we were like, you know what? We got to really dive into this case. So let's actually do that case.
It does.
Give it a full
It deserves
episode.
its own episode.
Exactly. You know, it's important because after the big Supreme Court decision in the Students Fair Admissions versus Harvard case that dealt with race admissions, affirmative action, this is a similar case, but as it pertains to K-12. There's just a lot to unpack with this case.
Yeah, there's a lot of movement in the law around issues of race-conscious admissions. So yeah, you mentioned the Students for Fair Admissions case that was recently decided by the Supreme Court, basically striking down race-conscious admissions is violating the Equal Protection Clause in higher education. In K-12, that had kind of already happened in 2007 with a case called Parents Involved versus Seattle Schools. But like, you know, connecting this not only to kind of these legal trends, but also to just societal trends right now. Like there's a ton of pushback, and not only in the states that, you know, we mentioned earlier with our bell ringers about like that are kind of pushing against larger efforts to promote diversity, equity, and inclusion.
Yeah.
And so like putting this case in that context, not only with the evolving law, but also within kind of this political context around these issues, like, you know, was really kind of a strong motivator for me to like think about why we ought to devote an entire episode to this case, even though we did just do this as a bell ringer.
Yeah, exactly. So, all right. So let's talk a little bit about what happened in this case. So we've got a high school at the center of this case, Thomas Jefferson High School for Science and Technology. It's in Virginia. It's in Fairfax County. It's a part of the Fairfax County public school system. All right. It's one of the top public high schools in the country, and it is considered to be a highly selective state chartered magnet school. So some of you might be asking, exactly what is a magnet school?
What's a magnet school, Jamie?
We'll tell you, or at least we'll tell you what the U.S. Department of Education defines as a magnet school. And the Department of Education defines a magnet school as a public elementary school, public secondary school, public elementary education center, or public secondary education center that offers a special curriculum capable of attracting substantial numbers of students of different racial backgrounds. Okay.
I think that's going to be important.
It is likely going to play a role in this case. So magnet, the term magnet, just refers to how these schools attract students across traditional school boundaries.
I had never put that together for why they were called magnet schools.
Yeah, no, that's why. Yeah, because it pulls, it attracts, right?
Yeah, no, that makes a lot of sense.
As a magnet.
Who came up with that?
I don't know.
That's clever.
But you wanted to be an engineer before all this?
Electricity and magnetism was not my cup of tea. No, thank you. I did very badly in that class.
So, so basically magnet schools are supposed to be designed to essentially promote desegregation by offering innovative curricula. Okay.
Mm-hmm.
So that's what a magnet school is. A magnet school can be theme-based, and sort of focus on visual or performing arts. It could focus on science, technology, engineering, mathematics, or they could include sort of distinct instructional models. Like you could have a dual language magnet school. You could have a Montessori magnet school. You could have an IB magnet school. So there's all kinds of different magnet schools out there. And it's generally left to individual states or local education agencies, LEAs, to further define what a magnet school would be for them. Okay? So Thomas Jefferson High School, it's a magnet school. It's focused on science and technology. It's one of the top public high schools in the country. It serves applicants from 5 different districts in Virginia. Okay, so that's the sort of region that it covers, that it pulls from. And its enrollment is around 2,000, so roughly 500 students per grade level.
Mm-hmm.
All right, so that's Thomas Jefferson High School.
So it's interesting to me that a lot of these cases that challenge kind of race-conscious admissions policies or like the distribution of admission based on race happen at these elite schools. Mm-hmm. So like we had the Harvard case, right? Like Students for Fair Admission versus Harvard. Mm-hmm. And then here we've got this elite high school. So like, that's just an interesting, I guess, thread between these cases where like, we're really looking at how these seats at these kind of elite schools are being allocated and whether or not race plays an impermissible role in how that is happening.
And the interesting follow-up to that, I think, too, is one of the topics that we'll talk about a lot in a little bit involving the legality of this is the concept of intent, right?
Mm-hmm.
And sort of what was the intent of the policy and blah, blah, blah. But as you mentioned, a lot of these cases seem to come up in elite schools, about elite schools, right? So along the same lines, the folks who are bringing these lawsuits, you've also got to ask, what's their intent? Right. And who are those folks at these elite institutions? Mm-hmm. Anyway, so here's the case. Thomas Jefferson High School is a magnet school, and so it has an application process. All right. It's got a limited number of seats, and it's got to fill those seats from across 5 different school districts. All right. And so the lawsuit came about because of the changes that Thomas Jefferson High School made to their admissions criteria. So let's sort of set the stage here for what was happening. So this was all around 2020.
Yeah, not much was going on in 2020, right?
No, nothing was happening. Nothing to see here. So
I don't remember much after, March of 2020.
Right, exactly. So before 2020, and 2020 was when the school changed their admissions policy. So before 2020, the students were still coming from one of these 5 districts, but they had to possess at least a 3.0 GPA, and they had to have taken algebra. They had to pay a $100 application fee and take 3 standardized tests, okay, just to get through the first round.
That's not the whole thing?
No, because after the first round, if you made it to the next round, you had to take another test and provide teacher recommendations and whatever.
Okay.
So what that admissions process resulted in was most students were coming from feeder schools in the school's home district, which was Fairfax County.
Okay.
Right? And few students were considered low-income students, which is, from what I understand, is kind of typical in magnet schools, is that there's a low representation of low-income, low SES students.
Mm-hmm.
In this school at the time, there were also few English language learners, few special education students,
Mm-hmm.
and few African American and Hispanic students.
Okay.
So the way this broke down, in 2019, about 20% of the student body was white and over 71% was Asian American.
Mm-hmm.
So one could ask themselves, I wonder if we're meeting our mandate as defined by what a magnet school is,
Mm-hmm.
which is to promote diversity, increase diversity. Are we meeting that objective?
Right.
Now, interestingly, a lot was happening beyond the pandemic in 2020 as well.
Mm-hmm.
So right around the time that the school published their admission statistics for the incoming freshman class, which was the class of 2024 at the time. So these folks are currently seniors right now. They're getting ready to graduate. So at the time all this stuff came out, they were in 8th grade. All right. And the school published admissions statistics for this class. Okay. And those statistics included so few Black students that they couldn't even report the numbers. So there were fewer than 10 out of the 500 or so incoming students.
Sure. Okay.
Who were African American. And the principal of the school at the time made some statements basically saying, I'm concerned that our school is not representative of the diversity that exists within our region.
Mm-hmm.
And we need to call for a curriculum that prepares graduates for a diverse and culturally responsive world. This was all following, this is right around the time of the George Floyd killing.
Mm-hmm.
Okay. So, this was an issue. This was a topic of conversation.
Right.
Right.
Yeah. And a lot of schools were grappling with those current events, with the Black Lives Matters movement.
Right. Totally.
Mm-hmm.
So that's the context of what was happening when all of this was going down. So also around that time, the Virginia state budget required schools like Thomas Jefferson to specifically set diversity goals. And Fairfax County School Board members were also expressing frustration with Thomas Jefferson's lack of diversity,
Mm-hmm.
especially when it came to underserved populations, disadvantaged populations.
Right.
The school board had been messing around with Thomas Jefferson's admissions process for about 10 years at that point,
Mhm.
but nothing really came of it. Right?
Sure. Well, if you're going to put that much emphasis on standardized tests, those have a very strong alignment to economic advantage and, especially for standardized tests, I'm looking at their statistics for English language learners and students with disabilities. I wonder what sort of accommodations there were for those tests and all of those different things. So it's one of those things where it's
what is your criteria actually doing?
Right.
And you're right. There is a lot of research out there that talks about which students typically perform better
Mhm.
on standardized tests, right?
Right.
So what happened was in June of 2020, what's going on is we've got this governor's task force that is focused on diversity, right, in Virginia, and is sort of pushing for these schools to do a better job in having diverse representation, right?
Mhm.
And so in June, a coalition for Thomas Jefferson formed and accused the governor's task force of Asian American discrimination. All right?
Okay.
Yeah.
So is that because the governor's task force was looking specifically at schools like TJ, was not targeting TJ, but was saying,
Yes.
hey, TJ, you're not
doing
racially diverse enough.
Yes, basically.
Essentially.
Yeah.
Okay.
Yeah. And so in September, so a lot of stuff started happening there. The superintendent and the board started doing a lot of work to try to figure out what to do about this, right?
Mhm.
So in September of 2020, the superintendent proposed modifications to the admissions process. What he proposed at first was this sort of lottery system based on merit, based on high GPAs. So a 3.5 GPA in the region, sort of across
Okay.
the 5 districts.
Mhm.
And, he showed up to these meetings with he had the data to show what something like this would do.
Okay.
In terms of how demographics would sort of play out, right?
Okay.
But nobody liked that.
Right. Well, and so, two things. One, the superintendent, Braband, I actually know that name. So he did his dissertation at Virginia Tech, and his dissertation was on Virginia principals' knowledge of school law.
Oh, cool.
Yeah, I've used his study in some of my work. So I saw that name and I was like, that's a pretty uncommon name. I wonder if it's the same guy.
That's really cool because
yeah.
Chris and I are both very interested in school administrators' understandings of school law. Mm-hmm. So that's cool. That's really cool.
Yeah.
All right. So nobody liked his proposal.
Right.
Including the Coalition for Thomas Jefferson that I mentioned before that was accusing the governor's task force of Asian American discrimination. So nobody liked this.
Right. And one of the issues was that he had the charts, like you said, he had the data, and one of them showed the estimated impact on TJ's racial demographics if they use this kind of merit lottery system, and that the estimates kind of showed that it would reduce the proportion of Asian Americans at TJ.
Yeah, exactly. Which is why the coalition was not in favor of this.
Or anybody.
Exactly. The board said that they weren't in favor of it largely because they wanted a school-based approach rather than a region-wide kind of approach. And so then a month later, in October 2020, he came back with a revised lottery proposal, which was still a regional approach, but it set seats aside for the highest evaluated applicants based on this sort of holistic application review process.
Mm-hmm.
Now, again, the board completely ignored that proposal and instead decided to just remove the application fee, the $100 application fee, and those 47 standardized testing requirements. I don't know. That's not an accurate. And they asked, what they asked for at that point was, okay, come back to us with another proposal that's not a lottery system.
Right. Because the lottery system, basically, if you meet the minimum criteria,
then we throw your name into a hat.
And, it was based on every region essentially got a certain number of seats.
Yeah.
Yeah. Okay. And so, this whole idea of a random admission doesn't seem to be going over very well with the board.
No. So they had lots of meetings and then they had more meetings. And so what happened was the superintendent then proposed this sort of holistic review approach, okay, where each district would get a certain number of seats allocated to them. And the board said, okay, we'll adopt a modified version of that.
We like that more than a lottery.
Right. So basically, what happened was the new admissions policy aimed to diversify the student body by including factors that went beyond academic performance. Okay. And they talked about things like experience factors. Okay. And those factors, those experience factors, included attending an underrepresented middle school, eligibility for free or reduced price lunch, being an English language learner, or having a special education plan. And so what happened was the policy also opened spaces for 1.5% of 8th grade students from each middle school, which would sort of aim to provide these sort of equal opportunities for students from less competitive middle schools, right?
So every middle school gets to essentially send 1.5% of its 8th grade population to TJ.
Right.
Okay.
And that would be evaluated based on GPA, based on this sort of portrait sheet, a problem-solving essay, and these experience factors.
Okay. Well, I'm glad they didn't get rid of all of the essays.
No, they didn't. And that left about 100 seats open that the school could fill from anywhere, right? Like public, private schools, whatever other applicants they might have. On the school's website, the current admissions process reads as follows. A holistic review will be done of students whose applications demonstrate enhanced merit. 550 seats will then be offered to the highest evaluated students. Students will be evaluated on their grade point average, a student portrait sheet where they will be asked to demonstrate a portrait of a graduate attributes and 21st century skills, a problem-solving essay, and experience factors, including students who are economically disadvantaged, English language learners, or special education students. So again, as I said before, those experience factors, special ed, free and reduced price lunch,
right.
ELLs.
And for the new policy, there was also something about whether or not you attended a kind of an underrepresented public middle school that hadn't been one of TJ's typical feeder schools.
Exactly. And that was included in one of those experience factors, right? So the board also said that whatever the process is, it has to use, quote, race-neutral methods and not seek to achieve any specific racial or ethnic mix, balance, or targets. And it's important to note that this application process, this new application process, those sort of applicant characteristics, so things like race, ethnicity, that kind of demographic information about individuals is not included in the applicant review process. So the people who are reviewing applications do not know race. They do not see any of that information. They just see an applicant number.
Okay.
You're assigned a number.
So not even the name?
I don't believe so.
Okay.
Okay, so what resulted from this new admissions policy, the number of applicants increased by about 1,000.
Gee.
Which is a lot. Students were admitted from all 28 Fairfax County middle schools, whereas previously students were only admitted from about 20.
Okay. So meeting that goal, right? Making sure that
every middle school is being represented there. More low-income students, more English language learners, and more females were admitted. GPAs overall increased. And what happened to sort of these demographic numbers, the Asian American population at that school dropped from around 71% to about 54%. Okay. It's also important to note, though, that of that 54%, there were more Asian American students from underrepresented schools and low socioeconomic status students than there were before in the 71%.
Oh, okay.
Right?
So there's more diversity within diversity then.
There's more diversity within that particular population.
Got it.
So I think the numbers were something like it went from one Asian American who came from a low socioeconomic status or an underrepresented school to about 51. Okay. So a significant increase in that subgroup. Right?
Is that a 5,000% increase?
It's a lot.
My math is not.
It's this is not a math episode. But it's also interesting to note that Asian Americans still got accepted under this new policy at greater rates than other students.
Oh, okay.
The number of Black and Hispanic students turned out to be around 10% of the applications and roughly ended up being about 8% of the 8 to 11% of the school's population, 8% for Black students, 11% for Hispanic students who were offered admission. And the number of white students also went up. It went from about 20% or so to 22%. So not a huge increase, but a small one. So basically what happened was this new policy did not sit well with a group of Asian American families. Okay. And so they decided to do what we like to talk about on this show, which is file a lawsuit.
Hey, look at that. All right. Yeah, so these families form this coalition for TJ, which brings this lawsuit, and they make one claim. They make the single claim that the new admission policy violates the Equal Protection Clause because it was motivated by a racially discriminatory intent to reduce the percentage of Asian American students who enroll in TJ.
So wait, they make one claim?
Yep, one claim.
So this is going to be a very quick discussion, right?
Yeah, it's not, one of the most complicated issues in American constitutional law. So yeah, I think 5 more minutes.
Yeah, right. Settle in, folks.
There's a lot to talk about here. Right. And so they bring this claim. Obviously, the board denies it and says, we weren't trying to discriminate against Asian Americans. We were trying to increase the diversity of TJ through this new policy.
Which they did specifically say is this race neutral policy.
Right. And race neutral. So like, when we talk about whether something is race neutral or race conscious, like race neutral basically means that like race is nowhere in the policy. So the policy itself does not make distinctions based on race. It doesn't say, if you get a plus factor if you're of this race, or, we're going to set aside this many seats for this race because that would be a racial quota, which is unconstitutional, all these different things. Right. So like race neutral just means that the policy itself makes no references to race.
Okay.
And even, we'll talk about this more, but like the thing that strikes me about the policy is also that like it is explicitly race blind in that they took out, like the policy itself, they took out racial identifiers for the applicants. So like people who are reviewing these have no idea.
Yeah.
Yeah. So like lots to unpack here, but essentially the argument that the coalition is making is that, the policy is race neutral, but you adopted it because you intended to reduce the amount of Asian American students at TJ. And because of that, like that constitutes impermissible racial discrimination against Asian Americans, which violates the Equal Protection Clause.
Right.
And so this gets to court, and the lower court actually agrees with that. So there's cross motions for summary judgment filed by the coalition and by the school. And the lower court sides with the families here. Mm-hmm. So against the school, actually. So they say that, yes, the new admissions policy was discriminatory against Asian Americans because it reduced their representation in the class, and because the board adopted it with specific kind of racial motivations. So the board adopted it because they were trying to essentially, in the language of the lower court, racially balance TJ's school population with the kind of larger community racial demographics. And so because of that, and because the board members talked about wanting to increase TJ's kind of racial diversity and all these other things that kind of were what the court would call indicators of impermissible intent, the court struck down the new policy and said that it violated the Equal Protection Clause.
But wait a second. The whole definition for a magnet school is to be able to sort of diversify, right?
Mm-hmm. To attract a diverse student body, right?
And the courts have sort of repeatedly said that schools can make efforts to do that.
Right. And the challenge here is we can make efforts to do that, but it's basically how schools use race in those efforts. So if your policy, is facially discriminatory, meaning that like it discriminates based on race on its face or in its terms, that's going to be problematic.
Yeah.
But equally problematic is when you adopt a facially neutral policy with a invidious, there it is again, intent to discriminate, where basically like you adopt this policy because of a desire to disadvantage some racial group.
Yeah.
And so that's kind of what the lower court was saying is like, they looked at this and said, you considered racial data, you talked about wanting to increase racial diversity. The proposal looked at the impact on these different racial groups, and you, school board, went ahead and adopted a policy knowing all of that. And you did so because you wanted to increase racial diversity, and that constitutes discrimination against Asian Americans. But that's not the end of the story, because that's the lower court opinion. This gets up to the Fourth Circuit, because the school appeals, and the Fourth Circuit actually agrees with the school district and upholds the policy. So the only question before the Fourth Circuit was whether the admission policy purposefully discriminates against Asian American students in contravention of the 14th Amendment's Equal Protection Clause. So same question, but we're looking to see whether or not there's purposeful discrimination.
Yeah.
And that's something that courts have, and the Supreme Court particularly, has looked at is, in order to violate the Equal Protection Clause, you have to have intentional discrimination, meaning that like the point of the law had to be discriminatory, like you had to be motivated by an intent to discriminate.
Yeah.
And so it's not enough just to have a disparate impact. According to the Fourth Circuit here, in order to kind of show a violation of the Equal Protection Clause for a facially neutral law, you have to show that it had a disparate impact and that it was motivated by a racially discriminatory intent.
Yeah.
And so the Fourth Circuit looks at this and says, like, are these things here? And kind of says, no, they're not here.
Right.
And we've talked about this a bunch, but the reason this matters is if you do demonstrate that the law was motivated by a racially invidious intent to discriminate, that triggers strict scrutiny.
Mm-hmm.
And most laws that get strict scrutiny fail under that standard.
Yeah.
But if you don't trigger strict scrutiny, if it's a facially neutral law, and there's no invidious discrimination here, you get rational basis, which is very easy. And policy is presumptively constitutional. So it all comes down to which level of scrutiny applies again.
Yeah. So it's constitutional unless proven otherwise.
Right. Exactly. So this question of whether or not you need to demonstrate a disparate impact and what disparate impact means is really important for the Fourth Circuit's opinion. It's also really important for Justice Alito's dissent from the Supreme Court's decision not to hear this case. So we talked about it in our bell ringer, the Supreme Court chose not to hear this case. So the Fourth Circuit decision stands. But in that decision, Justice Alito dissents and says, I would have granted review. And the reason he would have granted review, according to that dissent, is because he really disagrees with how the majority opinion here deals with this issue of disparate impact.
So he did what he did in Kennedy the first time around, right? Where he basically says, I disagree with this, and here's why. Here are all the different things that, should this come up again, this is what we're going to be. This is going to be top on my agenda.
Yeah, it's the exact same situation. It's the Alito cheat sheet.
Oh, Alito.
And so the question here about what constitutes a disparate impact. The school has one version of what a disparate impact is, and the coalition has another version. So for the coalition, they said that disparate impact means essentially we do this before and after comparison.
Yeah.
We look at what was going on before the new policy.
Yep.
We look at what was going on after the new policy.
Right.
And
we went from 71 to 51. There were more of us before, and there are fewer of us now. So that's a disparate impact.
Exactly. That's the argument that the coalition is making.
Okay.
And, that's the version of disparate impact, or let's just say Alito would endorse that understanding of what a disparate impact means. And so the school's version of disparate impact isn't about this kind of before and after comparison. Instead, the school argues that in order to determine whether or not something has a disparate impact, we need to do a kind of essentially a comparison between how well Asian American applicants do in relation to applicants from other racial groups under the new policy. And so if we're looking at this comparison, Jamie, you mentioned earlier, Asian American applicants still get into TJ at higher rates than other applicants under the new policy.
Mm-hmm.
So, they were something like 49-ish% of applicants, but they were 54% of offers. So you can see there's this big, they get more offers proportionally than applications.
Yeah.
And so the court looks at this and says, disparate impact, we are comparing basically how this race does against other racial groups. Here, there's really no disparate impact because Asian Americans are doing better than other racial groups under the new policy even.
Mm-hmm.
And, they may not be doing as well as they did under the old policy, but for our purposes, we're not comparing before and after. We're comparing.
It's how is this new policy playing out from a sort of holistic perspective, right?
In comparison to other groups.
Right.
Yeah.
Exactly.
Yeah. And this question of, and this all, it is esoteric, right? I'm not going to argue constitutional law isn't esoteric, but it has really important implications because this point of reference really matters. So if we use this before and after comparison, then any policy that impacts privileged groups or that kind of reallocates these sorts of seats or benefits or whatever it might be, it could be subject to strict scrutiny if the proportions change.
Okay. Gotcha.
And so what that would mean is it could essentially enshrine the status quo as kind of this legal baseline that any deviation from that could then trigger strict scrutiny.
Okay.
Or at least meet the disparate impact prong of what the Fourth Circuit requires to make an equal protection violation.
Okay.
And so there's this issue about we want the government to be able to address problems. We don't want to just kind of enshrine existing policy and kind of make that harder to change than it needs to be. And, the dissent picks up on this argument and basically says like, this is only one piece of the puzzle, but it's something that the concurring opinion here really cares about, which is this idea of kind of like putting the status quo on a pedestal. And, to kind of go back to what Alito's dissent from the decision not to hear this case at the Supreme Court level, he talks about like really disliking this approach. And, he gives a hypothetical that I think like, I don't know if it is a one-to-one application of the Fourth Circuit's reasoning here, but it does kind of raise some important issues, I think.
So like just high level overview of Alito's dissent is he was basically just saying he disagreed with the lower court's reasoning because he felt it allowed intentional racial discrimination to be constitutional as long as it wasn't so bad.
Right, exactly. And that was his overarching message was essentially, like if someone acts with a racially discriminatory intent, but does so in a race neutral way, like they could get away with it.
Yeah.
As long as the impact on that racial group, like they still did better or, when comparing that to other racial groups, they still performed well under the policy.
Right.
And so, that's Alito's big concern. I don't know if that's necessarily kind of the logical conclusion from the Fourth Circuit's opinion, but, it does kind of beg this question of like, what's our point of comparison for why we are looking for this disparate impact, or what do we mean when we talk about a disparate impact? Because, the reason disparate impacts are so important is because the Supreme Court has said the Equal Protection Clause only prevents intentional discrimination. One of the ways we can prove intentional discrimination is by looking at disparate impacts.
Okay.
Typically, folks don't come out and say like, hey, I passed this law in order to discriminate based on this racial group. We have to kind of look for indications of that intent. One of those indications is a disparate impact.
Right.
And so if we're looking at kind of like how these groups are impacted by these laws, it does seem to kind of matter how they used to do before the law and how they do after the law, but it also really matters how they do compared to other groups. So
exactly.
I'll be interested to see like when the Supreme Court takes this up, kind of how they navigate that question and how they navigate that question of like, why does this disparate impact matter? It matters because it goes to intent. And so the Fourth Circuit basically says like, hey, we don't find a disparate impact. We could stop there because under our law, you need a disparate impact and a discriminatory intent. And there's no disparate impact here under our understanding. So therefore, we could
be
stop.
Done. Yeah.
But
we have more to say.
I want Chris Thomas to read another 15 pages of opinions. So I'm going to keep writing. And so they look at this question of whether or not there's a discriminatory intent. And here the big issue is whether or not they had like that invidious discriminatory intent. And the bottom line that the court says is, look, the evidence of discriminatory intent is just too sparse. There's not enough here to show that they wanted to particularly impact Asian American students. And just because they knew about kind of what this policy might do for the racial makeup of the school, that doesn't mean they acted with an intent to make that happen, or like they were motivated by a desire to make that happen.
They weren't motivated by a desire to decrease the Asian American population.
Right, exactly.
Just because they knew that that might be an outcome doesn't mean that that was their motivation, right?
Right. Yeah. So it's this question of like knowledge versus intent. So according to the court, and this is a direct quote from the court, the board must instead be shown to have selected or reaffirmed a particular course of action, at least in part because of, not merely in spite of, its adverse effects upon identifiable groups. Stated differently, that a given law or policy may foreseeably have some adverse impact on a particular racial or ethnic group is not sufficient to demonstrate an invidious discriminatory intent. The decision maker must set out with that very purpose in mind.
Yes. So basically what they're saying is they're recognizing a distinction between an intent to reduce the Asian American population versus an intent to just better diversify their school.
Right. And that brings one of the counter arguments that the coalition makes, So the coalition made the argument essentially that the whole point of this new admission policy is to diversify TJ's enrollment. And we've got a lot of statements here that diversity includes racial diversity. And so because of that, the coalition is kind of trying to characterize this new policy as this racial quota system where they're saying like, look, yeah, you're saying diversity, but that means racial diversity. And you've talked about wanting to make TJ more representative of the community. And that means like essentially you want TJ's population to match the population of the community. So that's a racial quota.
But if you look at the policy, they're focused a lot, not on race. They're focused a lot on socioeconomic status. They're focused on underrepresented middle schools. They're focused on English language learners. They're focused on special ed. Those things are not race.
Right. And that's what the school argues and what the court ultimately goes with is like most of this stuff, it's a race neutral policy.
Yeah.
Right. Like the policy itself doesn't discriminate based on race.
Right.
And the court goes on to say, and I think this might be one of the strongest arguments they have. The court goes on to say that the Supreme Court has been telling us for decades that we can pursue diversity through race neutral means without running afoul of the Constitution.
Right.
And that is so important because it kind of demonstrates that like just because you're talking about diversity and race is an aspect of diversity, that doesn't automatically mean that when you act to pursue that goal, you are acting because of race.
Yeah.
Because if that were true, that means that anytime we pursue diversity, which the Supreme Court has said is a legitimate goal, we would be triggering the Equal Protection Clause
every single time.
Right. And that would be problematic because that would essentially mean that like, yes, it's a valid goal, but there's no way to do it without violating the Equal Protection Clause.
Yeah.
And that's something that the concurring opinion in this case really hits home. So Judge Hayton writes a concurring opinion. He joins the majority opinion in full, but he writes a concurrence to basically underscore the unusual nature of the coalition's claims. So Judge Hayton focuses on kind of these two issues that basically underlie the coalition's arguments here. The first is this issue of kind of the before-after disparate impact analysis.
Okay.
And he raises that point that we talked about earlier where like it can't be right that any deviation from existing kind of racial breakdowns would trigger additional scrutiny because according to this opinion, that approach would make it difficult to alter any existing policy. And so we don't want to kind of enshrine the status quo into kind of this elevated status.
Yeah.
But the other part of it goes to what we were just talking about, which is this question of whether or not you can pursue diversity through race neutral means. And
which, like you said, the courts have repeatedly said, including the Supreme Court, that's okay.
And here's the brilliant part about this decision, including Justice Alito in one of the Fisher affirmative action cases at the Supreme Court.
Wait. Are you saying that at some point in time, Justice Alito was taking a different approach to all of this?
So Justice Alito in his dissent in this case really didn't like the before-after test, but this is pointing out that like the Supreme Court, including Justice Alito, has kind of endorsed the idea that you can pursue diversity without intentionally discriminating based on race. And so, you know, they're different pieces of the same puzzle, but yeah, so like I think this opinion did a really smart thing by kind of citing to Justice Alito in the Fisher affirmative action case, which was one of the cases that upheld affirmative action in higher ed before the Supreme Court ultimately struck it down in Students for Fair Admissions. But in Alito's dissent in that case, he said that Texas could achieve its diversity goals without injecting race into the process by kind of these race neutral means of combining guaranteed admissions for each public high school students if they hit a certain kind of threshold, along with some race-blind holistic review.
Okay.
Interesting. A race-blind holistic review is exactly what TJ did.
Wait a second. So in the Fisher case, all right, that was an affirmative action case that was sort of ruled in favor of affirmative action.
Right.
And Alito said, I don't like that. I'm going to dissent. You should be able to do this
without reference to race.
You should be able to achieve diversity without specifically focusing on race
Right.
as a formal part of the process.
Right.
And now we have a situation where we are saying we have a process where we are not injecting race directly into that process, and our aim is to increase diversity. And he's saying, well, wait a second.
Jamie, you could have written this concurring opinion because literally the very next sentence of this concurring opinion after citing to Alito is, having spent decades telling school officials they must consider race-neutral methods for ensuring a diverse student body before turning to race-conscious ones, it would be quite the judicial bait and switch to say such race-neutral efforts are also presumptively unconstitutional.
Wow.
So, Jamie, you've hit the nail on the head. Like,
They called him out, huh?
well, maybe not him, but
They called the idea out.
and it is subtly aimed at him since he was literally cited in the sentence ahead of it.
I don't know. It doesn't seem so subtle to me.
Yeah, because that's the real concern here, I think, is like, if we can't pursue diversity as a goal because doing so constitutes intentional race discrimination because race is a part of diversity, and every time we did that, it triggered strict scrutiny, like that kind of puts us, going back to our conversation earlier, between like a rock and a hard place, right?
Yeah.
Like where we've got...
He's basically saying you can't have your race neutral cake policy and eat it too. No, that's probably a terrible...
He's saying you can't have your diversity cake and eat it too? No, I don't know how to fit that into this.
I don't know. I just like cake.
Who doesn't like cake? I think that's a good place to end the episode. No,
go get some cake.
And the other thing, like, not just kind of Justice Alito's opinion in Fisher that kind of shows that we can use these race neutral methods to pursue the goal of diversity. But that was a big part of the parents involved case in 2007. So Justice Kennedy wrote in his opinion in that case that and parents involved basically said you can't use race as an explicit factor in K-12 admissions decisions. And Justice Alito says if school authorities are concerned about student body compositions, they can and they're free to devise race-conscious measures to address the problem in a general way and without treating each student in different fashions solely on the basis of race. And so he lists all these other ways that school districts can achieve diversity through race-neutral ways that he says would not run afoul of the Constitution, even though they are race-conscious. So it goes back to that question of what constitutes intent.
Yeah. Exactly.
Knowledge of an impact doesn't mean you acted because of it.
Yes, exactly.
Right.
Yeah. So in this case, I guess, what we're talking about is their desire to create a more diverse student body that is more representative of the region that they serve. And just because they looked at sort of how their existing process was playing out in reality, and when they realized this is not achieving the goals that the Supreme Court has said we can work towards, that in and of itself does not mean malintent,
right,
and does not necessarily trigger that additional scrutiny, right?
Exactly.
Nor does it violate the 14th Amendment. Well, so where does that leave us as far as big takeaways? Pretty much in a very similar place to where we were before, right?
Right. Yeah. So the big takeaway here, I think, is where we thought we were before, where we can still pursue diversity if we do so in race neutral ways. But I think the flip side of that is even if we pursue diversity in race neutral ways, we have to be really careful that the way we justify those policies aren't based on invidious discriminatory intent.
Yeah.
And that's one of those things where it's a line and it's a spectrum between kind of knowledge and intent.
Yeah.
And where you fall on that is going to depend on the circumstances.
Yeah. And I'm oversimplifying this, but another way to say it is, it's very different to say, wait a second, I'm worried that we don't have a diverse enough population. So we've got to figure out additional race neutral ways to diversify. That is very different. And again, this is an oversimplification That is very different than saying, wait a second, we have too many Asian Americans and we need to decrease that number.
Right. Yeah. One of those is going to be much more constitutionally suspect.
Exactly.
Mm-hmm. And I think like the other thing that just kind of point out is like this case and Justice Alito's dissent and the dissent in this case as well, because this was a 3-judge panel and there was one dissenting judge, really kind of show maybe the like unsteady foundation of the court's jurisprudence on pursuing diversity as a goal. And so seeing how courts are going to continue to play with that idea is going to be really interesting moving forward because, you know, with Students for Fair Admissions, striking down affirmative action in higher education, like in much the same way that we talked about with religion, like there's a lot of potential here for judicial disruption of established law related to what we thought we could do when it comes to pursuing diversity.
Yeah. You know, I guess another way to put it is just because we might be saying in the Kennedy case and, you know, in this case and all of these other cases that have sort of percolated these last few years, just because we're saying, wow, these cases are really complicated, but, you know, nothing has really changed, like big time. What we're not saying is that means we're standing on very solid ground.
Right.
Quite the opposite.
Yeah. And things could change substantially in the future based on kind of the foundations that are being laid today, or foundations, to continue the metaphor, that are kind of being shaken up
and I
today.
think and I think that the operative word there is substantially. It's not just that things could change in the future. It's what these cases are showing is that things can change in the future in some really big ways, major ways, right?
Yeah. And they didn't in this case because it came out by a 2-1 vote.
Yeah.
I don't know what's going to happen in the next one.
Exactly. Well, I don't know. That's a good place to leave it, I think. It's lunchtime, so let's do some homework.
Were you that student too? Because I was that student.
What?
Doing your homework at lunch before you went to the class where you had to turn it in?
I was never that student.
What?
No.
Did you just not do your homework?
No, I did it the night before. Like, but like when I say the night before, I mean like if it was assigned 3 weeks ago. I didn't wait until lunch the day of, but I waited till the day before.
Oh, yeah. So yeah, maybe I perfected procrastinating so much.
Yeah. I'm with you. All right, what do we got?
Your homework. Find us wherever you get your podcasts, like, rate, review, subscribe, all of those great things. Find us on social media at Chalk and Gavel. We'd love to hear from you, get your feedback, your thoughts. If you have ideas for episode topics or bell ringers, we would absolutely love to hear that. You can go on our website, chalkandgavel.com. We've got a flyer up there if you want to spread the word about Chalk and Gavel. Tell a friend, tell your family.
All right. Well, then that does it for this week's episode of Chalk and Gavel. And we look forward to seeing you back here in a couple of weeks when we continue to talk about how the courtroom is connected to the classroom.